Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-1058, Secretary of Labor, Mine Safety and Health Administration petitioner versus Industrial Turnaround Corporation and Federal Mine Safety and Health Review Commission. Mr. Hartman for the petitioner, Ms. Chillemi for the respondents.
Good morning. May it please the court. My name is Edward Hartman on behalf of petitioner, the Secretary of Labor. After failing to timely contest a penalty assessment sent to its address of record, ITAC asked the commission to reopen the final order, but provided scant facts and little reasoning to justify the extraordinary relief of reopening the case. Just as it did in Westfall Aggregates, the commission abused its discretion by failing to engage with precedent and basing its decision on facts and arguments never presented by ITAC. This court has jurisdiction to decide the matter under the collateral order doctrine. This is a matter of great public importance. The matter is completely separate and apart from issues to be decided in a hearing on the merits and would effectively be unreviewable on appeal. I welcome the court's questions.
So it seems to me that you would have to take the position that this entire category of orders would be collateral and immediately appealable. That is, any time the commission grants a motion to reopen and remands, that would, in your view, be subject to an immediate appeal to us, that's important and significant. Is that right?
In final order that is dealing with the Mine Act, Your Honor, yes, because
So how many of these orders are we talking about per year that they're
I don't have
remanding?
I don't have.
There's several that are pending and.
Correct, Your Honor. I don't.
Go ahead.
I don't have an exact number on how many of these happen each year, but when in order, and they're not always contested by the Secretary of Labor.
No, I understand that, but if you chose to contest it, it would be a collateral order that would be immediately appealable. And this one is $33,000. Theoretically, there could be a $5,000.
Theoretically, Your Honor, but it just depends on the case itself and the reasonings given.
Right, and depending on whether you choose to appeal.
Correct, Your Honor, if we choose to appeal based on actions taken by the commission.
So why is this important? It has to be important, it has to be weighty, it has to be significant.
Correct, Your Honor.
And you litigate these things all the time. This is not like other types of cases we found to be weighty and significant, immunity cases where there's a right not to go to trial. So if you make them go to trial and then appeal, that vitiates the right. Here, you litigate these things all the time.
Correct, Your Honor. That's the job of the Secretary with regard to MSHA violations or violations of the Mine Act. What makes this important, though, Your Honor, is the Mine Act was put in place in 1977 for the specific purpose of ensuring that there are timely assessments and timely payments of penalties. And Congress determined that that was necessary to both.
How much of a delay are we talking about if you have to go and litigate this?
I'm sorry, Your Honor.
You said the importance is the timing. So how much of a delay would it be if you had to litigate this case as opposed to appealing right away?
It would have to go back. It would have to go through discovery. It would have to go through any motions practice. So the case would be sent back to the Secretary. They would file their petition for an assessment of penalties, and we start the whole process.
So that is, I just want to make sure I'm understanding you. That is what you view is significant and weighty enough to make this a collateral order situation, that there would be some delay in getting this fine.
No, Your Honor. The importance of it is the Secretary and the miners have a right, if an order is made final by statute, by the Mine Act, to have finality in the case. That's the whole purpose of the Mine Act.
There's a whole provision for reopening.
There is, and if you do reopen the case, Your Honor, it's up to the petitioner or up to the operator or contractor to give detailed explanations of why it should be reopened. And in this case, they didn't do that.
But you're just going to the merits. You just don't like the way it came out. That
No.
doesn't mean that this is a category of cases that's important or weighty.
It's the category of cases, Your Honor, is protecting the Mine Act and ensuring that the Mine Act put in place by Congress is maintained, that the miners and the Secretary of Labor know that if an applicant or a contractor or an operator do not timely contest a citation or an assessment, it becomes a final order.
So, Mr. Hartman, I mean, I'm interested here. Why does the Secretary of Labor here not contest the commission's authority to reopen a final order? I mean, there's no provision in the statute that gives the commission a reopening authority.
Your Honor.
And so I'm not sure, I mean, your argument that this is an important interest would be much stronger if the commission had no authority to reopen in the first instance. But you seem to have conceded that they do have this reopening authority.
Yes, Your Honor. The commission has both determined they have the ability to reopen, and this court has also allowed
Court has just said, that the commission has recognized this authority. We've never really reviewed that issue. I think the Secretary of Labor contested whether the commission had this authority in the original case, Jim Walters, that held where the commission decided it had this authority. But where does this authority come from? And I'm interested in why the Department of Labor doesn't continue to challenge whether they have this authority.
Your Honor, I think the Department of Labor has accepted the fact that there are times when a final order is adjudged or is deemed, and there may be good reasons for.
There may be good reasons, but your argument is that you have an interest in the finality of these orders when the finality is set by statute. So why isn't the next argument that they just don't have reopening authority?
Well, Your Honor, we're not saying that an applicant to reopen a final order may not have good cause or good reason to do that. There may be circumstances that rise to the level of granting the extraordinary relief. In this case, it does not. In this case, when ITAC petitioned the commission to reopen the case, it's simply said that you sent the assessment to the wrong address, and that's not the case. As the statute and regulations require.
I guess I just don't know how the Department of Labor gets past the third prong of Cohen if you're not making a broader argument about the commission's authority here. Because I'm not sure, I mean, Department of Labor is a government entity. It's trying to enforce its penalties. There's no important interest in the government not having to prove its penalties or to enforce the law. I mean, the department is choosing to enforce the penalty, and so it has to go through this process.
Correct, Your Honor.
How do you get past Cohen, the third prong of Cohen?
Well, Your Honor, in this case, when they did not give a reason for not providing or contesting the penalty assessment, it's up to them to let them know and let the commission know. And so when they don't do that, the commission is supposed to take exactly.
That's on the merits, but I mean, why is it an important enough issue to get within, the collateral order doctrine? I mean.
Well, because, Your Honor, Congress passed a statute to protect the nation's miners, and both the Secretary of MSHA and the nation's miners have an interest in making sure that these orders remain final. The whole purpose of the Mine Act is to protect the miners. And so it's very strict. I understand that, default is a very harsh penalty, which.
Let me ask you this, though. I mean, I'm just not that familiar with your regulatory regime, but you have a regulation that says that once a penalty is assessed, if it isn't challenged within 30 days, it becomes final.
Correct, Your Honor.
What's the statutory authority for that? Because wouldn't that be the same authority that would allow a regulation that says it can be reopened?
It's the Mine Act, and it says the commission is determined, and case law is determined that the commission may reopen extraordinary relief if good cause is shown. And so we accept that. We understand there may be reasons that a final order. I'm sorry, Your
No,
Honor.
no, please.
All right. There may be reasons, but it's up
So
to,
it's all case law. There's no regulation or anything that allows reopening.
correct, Your Honor. And so we accept that, and that's been the standard practice for years. And so, but if you're going to reopen a final order, you have to show extraordinary circumstances, and the commission has to give detailed explanations if it's not going to follow its precedent. So,
Oh, excuse me, if there's an objection within the 30-day period, and the commission believes that there's some merit to the objection, what happens then?
well, Your Honor, if within the 30-day period of, and I see that I'm over my time, but if I can answer your question, if an operator receives an assessment, they have 30 days in which to contest it. If they contest it, they send a notice to MSHA, and then at that point, the litigation starts on the merits of the underlying citation. So within those 30 days, that's a timely contest. If they don't contest that within 30 days, it becomes a final order under the Mine Act. That's why we're here today, because under the final order, if they're going to petition the commission to reopen a final order, they have to give sufficient justification for it.
If they just checked within the 30 days, you have all the same problems of delay that you're concerned with here.
Well, the statute allows them to contest it. That's their right. They have a right to contest the citations. But if they,
Right, but you also have accepted, as you said, that that the commission has the authority to reopen them.
they do, following their own precedent of demanding or requiring just cause extraordinary circumstances to warrant reopening. And in this case,
Objection is basically that this is a very poor case, not a good candidate for reopening because of the weak nature of the case for the employer.
we argue that the ITAC did not contest within 30 days, and they gave no reason why they didn't contest. Their only reason why they didn't contest is because they said that the assessment was sent to the wrong address, and it was not. It was sent to their address of record.
Seems that it's impossible, in your view, to separate the merits of their case from the finality. If they had a good case, we would not be here.
It would depend on the case, Your Honor. I mean, we can hypothesize of what excuses they're giving or what reasons they're giving. But in this case, they gave no reasons other than they alleged that MSHA sent it to the wrong address, and we did not. And at that point, they would have a duty to explain to the commission why they haven't been at that address for 14 years. And in that regard, would that rise to reason to reopen the case? I don't know, but they never gave a reason for why they hadn't updated their address in 14 years, Your Honor.
Yeah.
Mr. Herman, I just had one other question. I mean, why does this court have jurisdiction in a dispute like this that is essentially between two executive branch agencies, right? You have the Department of Labor suing the commission, which I understand is a so-called independent agency, but is still part of the executive branch. I mean, where do we have Article III authority to decide a dispute between two entities within the executive branch?
Your Honor, I would point to a Donovan case, which was the Secretary versus the Occupational Safety and Health Review Commission. This court looked at that case, exerted jurisdiction over that case, and it's two different agencies. It's mine safety versus occupational safety and health. But just like that case, Your Honor, we have the Secretary of Labor and FEMSHRC basically at loggerheads, a disagreement on how to best work the Mine Act, Your Honor.
And you think that's a proper Article III case or controversy?
Yes, Your Honor. With that, thank you for the court's attention.
Thank you.
Good morning. May it please the court, my name is Adrienne Chalemi, and I'm here on behalf of Industrial Turnaround Corporation. I will refer to them as ITAC as we do in our brief. Our arguments this morning are threefold. Number one, in answer to Judge Rao's question, this court does not have Article 3 jurisdiction to hear this appeal, and it should be dismissed. Number two, should this court decide to find that the category of cases that the Secretary argues should come within the collateral order doctrine, the Secretary did not abuse its discretion. If the court were to find that the Secretary abused its, that the Commission abused its discretion, the appropriate remedy is remand to the Commission for further findings, as has been the case in other decisions involving this issue and the issue of reopening. I will note that the case law that is available deals with petitioners who are operators or independent contractors, such as ITAC, who have had their motions for reopening based on the 60B standard denied, and not by the Secretary seeking under the collateral order to have an appeal from what is essentially a Rule 60B determination, essentially analogous to the vacating of a default judgment.
Let me, I understand the Secretary hasn't challenged this here, but where does the Commission get its authority to reopen a judgment that's made final by operation of law?
That is something that the Secretary did not argue. I think the timing of the Loper-Bright decision vis-a-vis when the briefs in this appeal were filed is certainly interesting. But the Secretary has not contested that the Commission may reopen. There are arguments that might have been made as well that are available, I believe, to ITAC as to whether or not ITAC in fact received the penalty assessment here under the specific terms of the statute.
If we were to review, if we were to find that we had jurisdiction and review the Commission's decision to reopen here under the abusive discretion standard, why wouldn't it be an abusive discretion if the Commission has exceeded its authority under 815A?
Well, Your Honor, perhaps that might be the case. However, I would also, the argument that I would make there that was never fleshed out in the courts below, and perhaps this is another reason why, if you are inclined to take jurisdiction of this case, the appropriate remedy is remand for consideration of these arguments as to whether or not there was an actual receipt of the penalty such that the reopening would even have been triggered. The word is receipt. The language of the statute, 30 USCA 815A, governs the situation in which refusal by the operator or his agent to accept certified mail containing a citation and proposed assessment of penalty under this subsection shall constitute receipt thereof. There's no such statutory language dealing with the scenario which we have here, which is where some unknown person, and my client has not been able, sort of a scribbled address on the receipt or scribbled name on the receipt to determine who in fact took receipt of the penalty assessment. So there are a number of arguments, and again, with the timing of all of this, we assumed that the agencies were entitled to discretion on the question that you are asking about whether reopening is permissible under the statute. We also assumed that the agency's position that, receipt means if it's delivered to the certified address and the address of record and signed for, well, it's signed for, but not by my client's personnel. And so I think there are a number of potential arguments there. But again, I do not believe that this case falls within the collateral order doctrine. The secretary has cited three other, I believe it's three other appeals that are on the same issue pending before this court. My review of the court's docket located another one. So, you know, there are Article 3 concerns. There are concerns that have been expressed by the courts about the efficient administration of justice. I seriously question whether the efficient administration of justice suggests that this court should be taking up interlocutory rulings utilizing a Rule 60B standard.
So if Judge Rao's insight is a correct one, which is that the commission doesn't have any authority to reopen because there's a statute that says once it's final and shall not be reviewable. Is that a jurisdictional question that we have to consider in this case, even though it hasn't been teed up by the parties? In which case, would we need supplemental briefing or a remand?
I think supplemental briefing or a remand would be appropriate. I mean, I've sort of puzzled through this a little bit when I was considering what the impact of Loper Bright might be on this case. Would it simply be that they didn't have authority? So then we are before the court again, appealing whether or not receipt under the statute means what they say receipt means.
My question, I guess, is do we have to confront the issue that's been raised by Judge Rao in this case?
No, I do not believe so, because.
But if they don't have authority to do it, we don't have jurisdiction, and jurisdictional issues can't be forfeited or waived. Is that right?
I believe that's correct.
So it seems like we might have to confront that issue.
Well, I mean, here ITAC is not directly challenging before this court the final default judgment. The Secretary of Labor is challenging the commission's reopening decision.
Correct. So that there is no final determination there. We'd at the very least request supplemental briefing on the issue.
Thank you.
All right. Thank you very much.
Thank you very much. Mr. Hartman will give you some rebuttal time.
Thank you, Your Honor, and I apologize for not requesting earlier.
Could I get your position on whether this is an issue that we have to address, whether the secretary and whether the commission even has authority to permit reopening?
I believe that this court, and the case is not at the tip of my tongue. I believe that this court has already determined that the commission has authority to reopen, to look at cases. Even if this court hasn't directly ruled on that this court has looked at decisions where the commission did reopen final orders.
Drive-by jurisdictional rulings are not binding on future panels.
Yeah, but going back to what
I guess my question just is, if there's an issue here about whether the commission has authority to even ever reopen a case, even though the parties haven't briefed it here, is that something that we have to consider because it goes to our jurisdiction to decide this at all?
Your Honor, we didn't brief that. If we need to do supplementary briefings, we're happy to do that. But this court does have a history of looking at cases that have been reopened by the commission. And so nobody has ever brought that up. ITAC has not brought that up, that there's no Article 3 jurisdiction for this court to look into this matter. We certainly did not brief it because we recognize that this court has jurisdiction and has looked at cases in the past. I would like to turn back quickly to the issue of ITAC wasn't sure who had signed for this document. As it's been briefed out fully and it's clear in the regulations, it doesn't matter who signed for it as long as MSHA sent it to the contractors or the operator's address of record. And it's up to the contractor or operator to maintain that address of record. And the question before this court would be, why didn't the commission look into why didn't ITAC update its record for 14 years, its address for 14 years? Thank you.
At your reply brief at page 12, you refer to 3 cases, opposing counsel just mentioned, 3 cases filed in this and pending here, all filed in 2024. And are they procedurally identical to the current case? Are they cases in which the commission reopened final order?
Yes, Your Honor. And it's similar issues that the commission has not followed its precedents and has not given detailed explanations for what it was doing. And in fact, Dino Novo, the first one, the last one listed, is almost identical to this case, where again, they did not update their address. And so that was their excuse for not answering the assessment. So they are similar, Your Honor. And that's why this court should take this matter up, because obviously under the final order, we don't want to get into piecemeal litigation. But in this case, this court can send the case back down. They can send it back down without remand because the commission did not follow its own precedents, because they came up with reasons for ITAC. They came up with argument on their own. In fact, as we stand here today, we still don't know why ITAC did not update its address of record. We only know that the commission thought, well, this may be a reason why they didn't update their record. And so that's where this case hinges on, Your Honor.
Thank you.
Thank you. Thank you.
Thank you.
Case is submitted.
Case number 23-5088, David J. Rudometkin, appellant, versus Christine E. Wormuth in her capacity as the Secretary of the Army. Mr. Trigger, amicus curiae for the appellant, Mr. Walker for the appellate.
Thank you, Judge Rao. May it please the court. Alex Stryger, as court-appointed amicus for Mr. Rudometkin. I've reserved 2 minutes for rebuttal. The question here is whether the district court lacked jurisdiction over Mr. Rudometkin's APA claims because they trigger the Tucker Act. This court's decisions in Kidwell, Tootle, and Smalls supply the answer. No, because Mr. Rudometkin's complaint did not ask for money, but instead sought only meaningful, equitable relief. And if there were any question whether Mr. Rudometkin sought money, the district court should have given him a chance to cure that jurisdictional defect. Because the district court didn't, this court should reverse. On our first point, Kidwell, Tootle, and Smalls establish a bright line rule for determining whether a service member's APA claims trigger the Tucker Act. This court looks at whether the complaint explicitly or in essence seeks more than $10,000 from the government. And this court has explained that a complaint does not, in essence, seek money when it requests only meaningful, equitable relief. Applying.
Mr. Trager, assume I agree with you that Mr. Rudometkin's claim is not one for money damages. And so there is jurisdiction over the APA claim. But Mr. Rudometkin would still need to get past the motion to dismiss. And so there's a question about whether he can meet the standards of APA Section 704. And, in particular, the question about whether there's another adequate remedy. So if we get to that point, is that a question the court should resolve, or do we need to remand that to the district court?
It's not a question the court should resolve, Judge Rao. And the reason is because the secretary has forfeited that argument. So that's our frontline position. And then I'll turn to why I think that there is no adequate remedy in the claims court. So our position principally is that this court should not consider the secretary's arguments under 704 because the secretary forfeited them. That argument is not jurisdictional. The secretary did not raise it below in moving to dismiss. And the secretary before this court has identified no exceptional circumstances to excuse that forfeiture. And I'm not aware of any case from this court, and you can maybe ask the secretary to identify one, in which this court has considered non-jurisdictional APA defenses that an agency forfeited and where there was no showing of exceptional circumstances. And I would submit that this case should not be the first. But putting forfeiture aside and sort of getting to the merits of the question, I don't think, Judge Rao, that the claims court can provide Mr. Rudometkin adequate equitable relief. And that's for the reasons that the Fourth Circuit explained in Randall, which is that under the Tucker Act, the claims court can only provide equitable relief when it is an incident to or collateral of an award for damages. And that's not the case here. And the reason that any equitable relief in the claims court would not be incidental to his claim for back pay is that Mr. Rudometkin currently doesn't have a viable claim for back pay because according to the Army, he's still in active service. And so a claim for back pay is only going to spring to life if the claims court first agrees with him on the merits and grants him the equitable relief that he's asked for in that court, which is similar to here, which is a recognition that the rescission order was unlawful, that he was discharged, and some sort of order requiring the secretary to recognize that. And so really it's the equitable relief that's driving his claims court action, not his request for back pay. And so
We do with his request that he also be released from incarceration. How does that factor into this analysis?
I don't think it does, Judge Pan. I think it's a request that he's made that the district court didn't take seriously, and I don't think, frankly, the district court could grant. And the reason is, and this is the one thing I think the district court got right in its decision below, is that this is not a collateral attack on Mr. Rudometkin's court-martial. Mr. Rudometkin is not challenging here or in the claims court either the Army's jurisdiction to refer charges against him or the court-martial or his sentence.
So we should just ignore that part of his complaint?
Not ignore it, Judge Pan, but what I would say is, first, it's indisputably equitable relief that he's seeking. It's not a request for money, so that doesn't trigger the Tucker Act. And so it doesn't factor into sort of the jurisdictional analysis. What I do think, though, is it's a request for relief that the district court doesn't need to and indeed couldn't grant. And just to sort of button that up, what he's really challenging is the rescission of his separation order in January 2016, 2 years before the court-martial. And I think it would be really odd to read the complaint as some sort of disguised habeas, particularly because Congress made clear in the APA in Section 701B that courts don't have jurisdiction under the APA to review court-martials. So to that sort of relief in subpart, I think it's D of the prayer for relief, the court couldn't grant that.
Mr. Trager, the government also suggests that Mr. Rudometkin failed to exhaust his remedies before the Army. And I'm wondering, is that claim properly before us? And if there is there any basis for this court to impose an exhaustion requirement?
So I'll take the two parts of that question in turn. On the first part, whether it's before the court, Judge Rout, the answer is no, and that's because the secretary has doubly forfeited that argument. They didn't raise it below, and again, it's not jurisdictional. There's no exceptional circumstances to excuse that forfeiture. And then the Secretary has not presented that argument properly before this court by relegating it to a cursory footnote in their answering brief. And I would point you to the Markham decision from this court, which I think is on all fours here. There, this court said that the final agency action defense was forfeited where the petitioner filed suit, subsequently went back before the agency, and the agency just never informed the district court of the pending agency proceedings. And this court said, you had a fairly good defense under 704, but you've relinquished it by not presenting it. So I don't think the court should reach it. As to your second question, sort of putting forfeiture aside, what to do about it, I think if the court harbors concerns there, the court should remand, because I don't think that the full record of the Army, of the proceedings before the Army Board of Record Correction is before this court. And it would be really hard, I think, to determine exactly what relief Mr. Rudometkin has requested before the board, what the board's reasoning was. And so that brings me, I think, to my second point.
Also, is there an exhaustion requirement in this context?
I'm sorry, the answer to that is no. Under Darby, the Supreme Court has made clear that an exhaustion requirement has to be found either in a statute or in the agency's regulations. And here there's neither. And I would point you to the Ostro decision from this court, which I acknowledge is unpublished, but is on all fours, relying on Darby and explaining that there's no exhaustion requirement here.
We should be suspicious of judge-made exhaustion doctrines, but I wonder if the military is possibly an exception to that because of the, respect for the executive branch in this context.
I don't think so.
Is there any basis for that?
No, Judge Rao. And again, I think this court has rejected that argument in Ostro. I think a number of district courts, which we point out in our reply brief, have similarly rejected this argument. The rescission order is a final agency action, and therefore Mr. Rudometkin was free to challenge it without exhausting before the board. I do want to make sure I briefly address, though, my second point, which is that if there were any question whether Mr. Rudometkin sought money, the district court should have given him a chance to cure that jurisdictional defect. As this court explained in Goebel, when the Tucker Act is at play, the decision to remain in the district court is the plaintiff's choice. Mr. Rudometkin wasn't given that choice, and the district court's finding that amendment would have been futile was wrong. We know that Mr. Rudometkin would have relinquished the right to recover more than $10,000 from the government because he said that repeatedly in his submissions before the district court, and he's now said the same thing in his filings to this court. So it wasn't futile to cure the jurisdictional defect here. All Mr. Rudometkin had to do, if there was any question, was file an amended complaint that just expressly relinquished the right to recover against the secretary, and he's more than willing to do that.
If you're correct, though, or if the court agrees with you that the complaint, as it is not a money complaint, why would we need to address the denial of the motion to amend?
You would not, Judge Ginsburg. In that scenario, if you agree with us that there's jurisdiction, you should just reverse with directions for the case to proceed forward. Thank you.
Thank you.
Good morning, Your Honors. Johnny Walker for the Secretary of the Army. Your Honors, over the course of 2 weeks, Mr. Rudometkin filed 2 duplicate claims, one in the district court here and one of the United States Court of Federal Claims. Both of those cases challenge an order rescinding his retirement, and they both seek money connected to that rescission. The only difference is that Mr. Rudometkin does it explicitly in the Court of Federal Claims by mentioning back pay, and does it only essentially in the district court here by asking to be put in the same position had he retired in 2016. That necessarily would entail payment of back pay connected to the retirement as part of that make whole relief.
Are there any cases in which we consider whether a claim is in essence for damages? I mean, it seems like under Kidwell and Tootle, that's not permitted. We just have to look at the complaint. Our cases have suggested that there's a bright line rule.
Well, what Kidwell says is there is a bright line rule to look at the complaint only, but what Kidwell says is that the court has to be careful of plaintiffs who are disguising what are essentially money claims as equitable claims. and therefore trying to forum shop in the district court rather than to go to the Court of Federal Claims. And there's no clearer case of forum shopping, I believe, than what Mr. Rudometkin is doing here. He has duplicate claims pending in both the Court of Federal Claims and the district court. So under Kidwell, the court should look to the substance, is what the word that Kidwell uses, look to the substance and not only the form of the complaint to determine whether it essentially seeks money. And here it does, not only in the form of asking to be put in the same position had Mr. Rudometkin retired in 2016, but there are also other structural aspects of this claim that make it appear as a Tucker Act claim and not an APA claim. The big one is that Mr. Rudometkin has obtained a final agency action from the Army by exhausting his claims through the Board for the Correction of Military Records. And in an APA case, it is that decision by the board and the record associated with that decision that is the final agency action under review. But Mr. Rudometkin here targets the underlying order that was issued in 2016, and that gives it the appearance of a Tucker Act claim. I think this is explained well in the Hansen case from the 10th Circuit that we cite that is not directly on point in terms of its holding, but provides a useful discussion of the difference between an APA claim and a Tucker Act claim. It's also apparent, I think, in the Martinez case that we cite in the Federal Circuit that notes that a Tucker Act claim accrues at the time of the original order and challenges that order, whereas an APA claim accrues at the time of the board's decision. So because Rudometkin's claim here both challenges the underlying order and seeks make-whole relief, including damages in its request to be put in the same position, it is a Tucker Act claim in essence and in substance and should be brought in the Court of Federal Claims. Separate and apart from the jurisdictional Tucker aspects, there is also the argument that even if the court does have jurisdiction, and this is not a money claim, it is subject to dismissal under the APA because Mr. Rudometkin has another adequate remedy in the Court of Federal Claims. And I first want to get over this.
So, yeah, let's talk about forfeiture.
Sure. I don't think this is an appropriate case for forfeiture. I mean, this court has held that a fully briefed issue on a core legal tenet is subject to appellate review. Here, this was not part of the government's motion to dismiss in the district court. The court had its own sua sponte reasons for dismissing the claim, but other adequate remedy was one of the reasons that the district court gave for the dismissal. It was raised by amicus in the opening brief and argued by amicus in the opening brief. So I don't think that amicus can argue that they are permitted to make that argument, but then we are blocked by forfeiture from responding to that argument and offering an argument on that issue of our own. And it's not just confined, that's on another point. So I don't think this is an appropriate case for forfeiture. It's fully briefed, it was part of the district court's decision, and it's an important issue. And I think it's a relatively straightforward issue because you don't see many cases where the question of other adequate remedy is as easy as it is here because you both have a theoretical other adequate remedy in the fact that we know the Court of Claims has held that the Army's retirement statutes are money mandating statutes that can give rise to a Tucker Act claim in the Court of Federal Claims. And the Tucker Act itself, specifically in the statutory text, says that the Court of Federal Claims can grant placement and appropriate retirement status in connection with the Tucker Act claim in the Court of Federal Claims. So not only is there an adequate remedy very clearly in theory, but here we also have that adequate remedy playing out in practice. Mr. Rudometkin has, in fact, brought precisely that claim in the Court of Federal Claims. The government moved to dismiss, but purely on ripeness grounds, and in that motion to dismiss, acknowledge that Mr. Rudometkin can challenge the rescission of his retirement as ultra vires in that court. The Court of Federal Claims ended up granting the motion to dismiss on ripeness, but that was overturned by the Federal Circuit. So Mr. Rudometkin's name is out pending, but stayed in the Court of Federal Claims. So not only does he have
The simplest way to resolve this case is to say, well, the district court did err because it believed that this adequate remedy aspect was a jurisdictional issue as opposed to going to whether it's, he stated a claim under the APA. So that's wrong. And so we reverse and remand and let the district court sort through the rest of this.
I don't think there's any reason to believe that the district court would reach a different issue. Whether jurisdictional or non-jurisdictional, it is still a basis to dismiss the complaint where there's another adequate remedy in another court.
Except that you didn't argue it that way.
Again, we didn't argue it that way, but it was part of the district court's opinion. It was argued by amicus in the opening brief. We responded to it in our brief. It's a fully briefed issue that the court has before it. And we think it's a basis to affirm, given that the district court would reach the same decision on a 12b6 posture.
What about exhaustion? I mean, the government here suggests that Mr. Rudometkin didn't exhaust his claims. Is that properly before us?
I'm glad you brought that up, Your Honor. I first want to clarify the nature of the government's argument. Our argument is not that Mr. Rudometkin had to exhaust. That's frankly a difficult question, how this circuit's decision in Boyes plays out post-Darby. Boyes, of course, was based on unique considerations relative to the military. It recognized a well-recognized and well-documented and well-established principle that courts generally defer from interfering in direct orders from a commander to a member of the military and instead wait for the intra-service remedies to play out. Darby dealt with a civilian final agency action. So there's a difficult question there. It hasn't been briefed in this court. And our argument is not that Mr. Rudometkin had to exhaust and that he failed to exhaust. Our argument is precisely the opposite, that he did exhaust. But by doing so, he obtained a final agency action in the form of a decision from the Board for the Correction of Military Records. And it is only that final decision from the board that is subject to APA review.
I also just had, are there any justiciability concerns about this court deciding the APA claim before the military courts have finished with their process? I know that's not something the government has briefed here either, but there's some, there are some concerns about that have been expressed in other cases.
I think that is true. I think that those concerns are expressed in Boyes and in the Mindy's case from the Fifth Circuit that it relies on. And I don't think there's anything about Darby or anything from this court post-Darby that I know of that directly addresses those concerns and reconciles them with Darby. Again, though, that's not the nature of our argument. Our argument is that Mr. Rudometkin did exhaust his administrative remedies, whether required to or not. The fact is that he did. He did it while the suit was pending to go to the forfeiture point. By the time the government...
Not about exhaustion. I mean, the fact that the process is still, his appeals are still pending in the military courts, aren't they?
Yes, they are still pending in the military courts, and that's sort of a separate issue. He's not directly... I think he has exhausted through intra-service remedies through the board his request for a retroactive retirement.
My question was about the courts, the military courts.
And I think that does raise a concern, Your Honor, because he has raised this before the court-martial. I don't know that there's an exhaustion requirement that he do so before the court-martial, but if this case were to go forward in the district court, we think it would be prudent to do precisely what the Federal Circuit ordered the Court of Federal Claims to do, which is to stay the case pending the outcome of the court-martial proceedings. I just wanted to address the issue of exhaustion with respect to finality really quickly that my friend brought up. This is not something that we can find, or not exhaustion, but final agency action is properly characterized. Our final agency action argument was not something that we confined to a footnote. We discussed it at some length on pages 35 to 38 of our brief. And we believe it is well preserved. And again, the reason that it was not raised by the government in its motion to dismiss is that the board decision here did not issue until after the government moved to dismiss. And it was only sort of in Mr. Rudometkin's reconsideration papers in the district court that he began attempting to reframe his claims as a challenge to that final agency action in the form of the board's final decisions. Now, importantly, Mr. Rudometkin can still bring that claim. Those decisions were just issued in 2002 and 2004. The statute of limitations would run from that time, and the district court's dismissal here was without prejudice. So to the extent that he can overcome other hurdles, he could bring those claims notwithstanding the statute of limitations and the final agency action requirement.
Any further questions?
Thank you, Your Honors. Please affirm the district court.
Starting with jurisdiction, the Secretary is arguing to this court that Mr. Rudometkin's complaint essentially seeks money based on the complaint he filed in the claims court, echoing the reasoning of the district court. That is inconsistent with what the Secretary said on page 24 of her red brief, that the court should determine jurisdiction based only on the complaint filed in DDC, which again is this court's strict pleading requirement. It looks to the four corners of the complaint before it. The Secretary's argument is also inconsistent with Tootle and Smalls. In both of those cases, the plaintiff had filed other complaints in other federal courts where they explicitly requested money. And yet this court didn't look at those complaints and didn't compare the complaints in the other federal forum to the complaint filed in DDC. It looked only at the four corners of the complaint filed in this district to determine whether that complaint triggered the Tucker Act. And to the extent that the court has any concerns about sort of Mr. Rudometkin's dual proceedings, I would submit that this court has a well-trod path for handling those situations in which the first in time case proceeds and the subsequent case is stayed. And so what should have happened here is Mr. Rudometkin's first in time district court action should have gone forward while the claims court should have waited. On forfeiture, I think, Judge Pan, you're exactly right that these arguments, because they're not jurisdictional and they weren't raised below, and there are no exceptional circumstances to excuse the forfeiture, the court shouldn't reach those issues. Instead, the court should reverse and remand. And if the secretary wants to raise them, it can do so later in the proceeding, such as summary judgment. And so for those reasons, we'd ask the court to reverse and remand.
Thank you.
Thank you.
Case is submitted.
Case number 23-7176. Michael D. Hurd Jr., appellant versus District of Columbia. Mr. Ginsburg for the appellant, Ms. Van Zyl for the appellee.
Good morning, Your Honors. May it please the court, my name is Doug Gansler, and I represent Michael D. Hurd Jr., the appellant in this case. Instead of the district taking the morally and legally tenable position that it should not be locking up its own citizens without due process, either procedural or substantive, this is actually the third bite at the apple that they have, that the district has gotten by appearing before this court. And this court has reversed and remanded in both instances, and we ask the court to do so again today. Indeed, the appellee has tried every technicality to advance their position that the appellant, a real human being, should not be able to bring his case before the jury to determine whether, despite a specific order that was given that he was to be released at 7 o'clock on October 2nd, 2011, for his 3-weekend sentence for smoking pot, they decided unilaterally to hold him for another 2 years and put him back in jail with murderers, rapists, pedophiles, and the like.
But he had a sentence to serve. It's not like they did that out of the blue.
Well, our position, Your Honor, is that he actually did not have a sentence to serve because he had been released 4 years earlier from his sentence and was at
I thought your
liberty.
position was he had a lesser sentence than what was on the books. The dispute there was it 14 months or 27 months?
No,
He still had time to serve.
our position has been and was from the moment that Mr. Hurd found out at 7 o'clock that he was staying there, and he said, I've already done that time. When do I go to court? When do I get my lawyer? That his sentence had expired actually on June 18th, 2010, when the parole agency successfully terminated that sentence. And he had been out at liberty, he'd been on the streets, he'd satisfied every component of his time.
He was at liberty because of a mistake.
He was at liberty because they let him out. He was unaware of the reason for why they let him out from the federal penitentiary. But it was a mistake, but it was not a ministerial mistake. We get into the factor, but there's the substantive due process argument, which this court has already addressed. The standard in DC is obviously the Merritt case. And then since Merritt, there's Lewis.
That's not the standard of this circuit. It's a district court opinion from 1979.
Yes, but it has been. It was cited by this court, by the two panels that have already heard this court have cited it. And it's actually been used in many other circuits that are in our brief. It was used in this case at both the habeas hearing and at the district court level. And every argument that's come up here has been about merit because it's the seminal case regarding reincarceration. Now, since then, Lewis was decided by the Supreme Court. And that, as Your Honor knows from previous cases, is about the shock to the conscience standard. Now, the shock to the conscience standard has been around since 1952 in the Rockland case. It got somewhat elevated in the Lewis case. Now, that was a case about a police chase. And what's interesting is this court, in Judge Pillard's opinion, in the first one, it said, still, Lewis recognizes that when officials have the luxury of time to make unhurried judgments as they had here, and such extended opportunities to do better are teamed with protracted failure, even to care, indifference is truly shocking. If this case were to return to this court, we trust that the parties would focus on whether merit should become the law of this circuit, factoring in the Lewis shocks the conscience threshold while accounting for the arguably non-existent
The question is
circumstances.
whether merit should be incorporated. So what's your argument that we should incorporate merit?
Well, because merit has not been overturned. Merit's been used as recently as, this year by every circuit there is.
It didn't rely on substantive due process, though.
Excuse me?
Merit did not rely on substantive due process.
Well, merit is a substantive due. My understanding is that it's a reincarceration case and whether or not it shocks the conscience.
Yes, it is a reincarceration case, but it doesn't rely on substantive due process. It's more like sort of equitable and estoppel principle.
Well, that's one of the concerns. So the factors that are set forth in merit are whether the results attributed to the defendant himself, and everyone agrees, I think the district concedes that that's the case here, that the action must be more than simple neglect, and we have many instances of that, including the fake face sheet, the 3-page face sheet that they doctored to say that he actually had a hearing when he had not in this case, plus all the other
I'm sorry,
reasons.
what's your argument for why this was more than neglect?
Well, there's a lot of arguments. The one that will ultimately before the jury is that Mr. Seibert, who is essentially a paralegal at the Department of Corrections, and unilaterally decided to leave.
Well, he asked a supervisor.
He asked a supervisor, and in fact, the district then defended, the United States Attorney's Office defended the case, and so it's the district's decision ultimately from a legal standpoint.
I mean, it just doesn't sound negligent. You might not like what he decided, but anyway, go ahead.
Well,
Why is this more than negligent?
But everybody else in the government, the parole, Mr. Hurd for 3 years was in supervised release. Nobody mentioned it. He had contacts with the court. Nobody said he had a
But why is
sentence.
it negligent? Go ahead.
Well,
Give me your best argument for why this is more than negligent.
The biggest, I mean, there's a lot of factors, but the most important factor is the 3 pages of what's called a face sheet, which the court can find in the joint appendix, in the second joint appendix before this court on A439 to A441, which Judge Pillard was very obviously concerned with in her argument, in her opinion about this case when the Superior Court judge decided he would not allow the document in.
I'm sorry, where is the face sheet? A439?
Not in, it's in the joint, it's in the joint appendix for the second time this case came before the court.
Oh, not in our current joint appendix.
No, because it never got, unfortunately, this has been up here 3 times on summary judgment when we've never gotten to the facts, and that would be probably the biggest piece of evidence that we have.
Okay, so explain it to us because we haven't seen it.
Okay, well, yeah. Well, it was argued at the habeas hearing. It was actually an attachment to the DC Court of Appeals appeal that they took 1.5 years to not decide and then mooted it because Mr. Hurd was out. And then it was discussed in this court at a prior hearing. What it says is they actually went, they knew they shouldn't have done this. They had time. There was no exigent circumstances. Mr. Hurd had shown up the weekend before.
What does it actually say?
It says that he had
say, I know we shouldn't have done this.
Well, it says he had a hearing date on October 3rd, 2011. Remember, he was not released the night before on Sunday night at 7 o'clock. Everyone got to go home. He didn't. They said, oh, you get to stay for another 2 years for smoking pot. And now they said they had a hearing date on October 3rd, 2011, and a sentencing date October 5th, 2011. Neither of those things happened, and it's on a DC.
I'm sorry, I'm just having trouble understanding your argument.
So there's something called a face sheet, like a face, and it talks about the sentencing notes and the charges, and it's a document from the DC jail. And in that document, it talks about the different charges and what's happened in the case. Right in the center of the page, they doctored this, and it's signed by
We're not finding any of those facts in this,
No,
at this.
of course not. But what we should submit there is to the court is that there are genuine issues of material fact that the jury needs to look
So
at.
assume that assume for a moment that we are not going to incorporate the merit factors. What's the best argument that what the district did here shocks the conscience under Lewis? I mean, here it, arguably is just an ordinary, administrative mistake that they corrected. What's conscience shocking about what the district did here?
Well, I would submit that any reasonable juror would find that somebody who goes to jail on a court order for 3 weekends because they had less than 2 ounces of marijuana, that ends up getting told they're now going to stay there for 2 years with no due process, no pre-deprivation hearing under the United States Constitution,
There was a final judgment from his earlier crimes that he didn't serve due to an administrative error.
right, but he satisfied all the case law, including merit, but not using merit, but the case law talks about that if you are time at liberty counts toward your sentence. And he got out this thing started in 2005.
How is this, maybe this isn't a great way to run a railroad, by the district, but why does it, shock the conscience?
Well, I would submit that any juror who went to jail for a crime that actually is no longer a crime, nor was his original crime, they go to jail for smoking marijuana. They think they're coming back Sunday. They think they're going to work the next day, and they find out they're going to be locked up in DC jail with the people that are locked up with in DC jail for 2 years, and you never get to see a judge. You never get to have an argument.
But because he had a sentence to serve,
But
I don't see how a jury wouldn't find that highly significant, that he actually had a sentence to serve. And so they held him to serve the sentence that
well,
was entered.
there's a number of arguments there. First of all, the case law talks about inconsistent with fundamental principles of liberty and justice. So the question is, he did not, with all due respect, Your Honor, he did not have a sentence to serve anymore.
So I understand your argument in that respect to rely on this time at liberty theory, which is that he should get credit for time at liberty and credit that against jail time. And that was rejected when he finally had a habeas hearing before Judge Holman. Understandably, it wasn't immediate. It was 10 minutes later. But Judge Holman rejected that and relied on Wells and other DCCA cases, right? So assuming that we don't buy the time at liberty argument, as the Superior Court didn't, where does that leave you?
Well, I certainly hope you do, because the case law is pretty clear that is something you should buy. But I think that it leaves us with the idea that somebody who thinks that they are been released properly, the entire government, both federal and local, thinks they've been released properly, has been living their life as a normal citizen, who was locked up as an honorably discharged Marine in the first place for having a proper license for a gun in his state of North Carolina at the time. 2 years later, that becomes not a crime anymore, and he's still serving his sentence. And then he's locked up for marijuana, less than 2 ounces. I would think any juror, and certainly everyone I've talked to about it, would believe that this is beyond outrageous and shocks the conscience. And merit, the circumstances here are much worse than the merit, just the facts. I understand the court is reluctant for whatever reason to rely on merit, but under Lewis, again, the facts are very different. That was a legitimate police conduct. They were going after somebody on a high-speed chase. This is a reincarceration case. They just can't lock people up and then say, oh, 10 minutes later, as Judge Bates said, in his opinion, would have been a different, if it had been the hearing at the time, could have been a different judge. In fact, it was. Judge Von Kahn was assigned to the case. Different judge, different lawyers, different situation, because Judge Holman, and this goes to Your Honor's argument, question about the 14 months versus the 24 months. Judge Holman knew that that Michael Hurd only had 14 months left, because he wrote it in his opinion, and Judge Bates in footnote number 6 in his original opinion says, this is not a dispute, this is a fact. He wrote their time served for each of the cases, so he's only had 2 more months to serve.
We're out of time.
Sorry.
I don't know if my colleagues have further questions.
Thank you, Your Honor.
Good morning, Your Honors, and may it please the court. Caroline Van Zyl on behalf of the District of Columbia. I'd like to start with the proper standard for proving a substantive due process violation, because that standard is extremely high. The Supreme Court has said that only the most egregious official conduct can constitute a substantive due process violation, conduct that shocks the conscience. And as to whether the merit standard can be reconciled with the high bar set forth in Lewis, the answer is that it absolutely cannot. And that is so for several reasons. 2 prongs of the merit analysis in particular are just plain inconsistent with modern substantive due process jurisprudence. The first is the prong that says the action of the authorities must amount to more than simple neglect. Even Mr. Hurd concedes in his opening brief that that is not reconcilable with modern substantive due process jurisprudence. It doesn't meet the required level of egregiousness. And the other prong of merit that's just irreconcilable with modern substantive due process jurisprudence is the requirement that the action be inconsistent with fundamental principles of liberty and justice. As the Fourth Circuit said in Hawkins, that fails to embody the full stringency of Lewis's requirement that an executive act must be not only wrong, but egregiously so. And applying that proper standard to the conduct at issue here, it simply doesn't meet the bar of shocking the conscience. And one way to know that is to look at other analogous cases that have addressed the same issues of erroneous release and reincarceration.
DC doesn't challenge here the district court's holding that Mr. Hurd has a protected liberty interest. So is it the district's position that that a person who was mistakenly released from prison has a protected liberty interest in
No, Your
their
Honor.
freedom? I'm interested in why that. So that, I mean, that's the position that the district has. Then it seems that, you know, I mean, is that the district's position?
That is not the district's position, Your Honor. We did move for summary judgment on the procedural due process claim, and we did not move for summary judgment on the liberty issue in particular, but there could be a lot of reasons for that, including perhaps there might be disputes of material fact around that.
Well, didn't the first appeal of Hurd, didn't Judge Pillard say that there could be a liberty interest here?
Could be, I think is the operative language, yes. Now, in the district court on summary judgment, we didn't take issue with that. We took issue with the kind of process that was due, whether it needed to be pre or post deprivation. Judge Bates did not grant a summary judgment on that ground. We have not renewed those claims before this court. So I don't think that issue is before the panel. That said, there was no renewed cross motion for summary judgment. So I also don't think that it can be treated as conceded. Again, I think it's just an issue that in the event of a remand, which of course we hope to avoid, could go to a jury. So turning back to how the Lewis test applies in circumstances like this, I think the Fourth Circuit in Hawkins got it exactly right. When you're talking about erroneous release and reincarceration, you're talking about a phenomenon that is surprisingly widespread and recurring in both state and federal penal systems. And in this context, the routine, seemingly invariable executive practice has been to reincarcerate, rejecting any claim of entitlement to freedom, no matter what the circumstances. And in Lewis, the Supreme Court admonished lower courts to come to an understanding of traditional exercise of executive behavior, of contemporary practice, and of the standards of blame generally applied to them. And so when we're talking about such a widespread and routine practice, even if unfortunate, in a circumstance like that, the standard of blame required to show a violation by an executive actor is extraordinarily high. It's certainly higher than the merit standard. The Eighth Circuit in Bone Break concluded that it was so high that it would be beyond deliberate indifference, which is only sort of a mid-level standard of fault. And so again, in terms of substantive due process, we would urge this court to side with the many other courts that since Lewis have held that.
If I can just ask you a question about how often does this occur, this type of error? And, in litigating cases like this, has the district put in place any procedures to address this kind of problem?
So these sorts of errors, according to Mark Seibert's deposition testimony, are exceedingly rare. Anything like this happens sometime between maybe 2 to 4 times per year. And when I say something like this, I don't necessarily.
Wait, in the district?
In the district, that was his estimate at the time. That said, that includes situations where a district detainer was perhaps missed or ignored by another jurisdiction. We're not just talking about miscommunications between the Bureau of Prisons and the Department of Corrections when we're talking about that still very small number. Now, at the time, there was no procedure or policy for exactly how to deal with this problem. I can say this is not in the record, but in having conversations with my client, if this were to recur today, the way the Department of Corrections would handle it would be to have a conversation with the Superior Court to alert the parties to the case, and then the Superior Court holds some sort of special hearing and a warrant either issues or does not issue. So that is how it's handled these days. Obviously, at the time these events unfolded, there was not that same practice, yes.
So it's just a more prompt hearing. It's not a pre-deprivation hearing, probably. It's just more sooner than 10 months.
I don't have the amount of clarity that I would wish to tell you whether it's pre-deprivation, post-deprivation. It may depend on the circumstances, but my understanding that there is a hearing in front of the judge to determine whether someone is owed credit for time at liberty, whether there's been some sort of mistake, whether the person has served their sentence, that sort of thing. So if there are no further questions on substantive due process, I'm happy to turn to procedural due process. The issue on procedural due process is whether or not the district sufficiently showed that there was no prejudice from the alleged lack of procedural due process. We submit that they have. Mr. Hurd has 2 preserved theories as to why there might be some prejudice. Both fail for multiple reasons. We can start with the time served credit theory, which fails soundly, I think, on the merits. Other states have looked at this issue as to whether you should have your time served counted once or twice or 3 or 4, or as in this case, Mr. Hurd alleges 5 times. They have uniformly, as far as I can tell, and as far as Judge Bates could tell, held that time served before sentencing is counted only once. We've also put in the record a sentence computation manual that says the same thing, and a declaration from a DOC official saying your time served counts once. It doesn't count towards each of your individual counts. It counts towards the term of your sentence.
Although the DCCA hasn't resolved that conclusively, so could we be the ones to resolve that? Isn't it easier to say that this makes no difference because if we're going to the time served thing, it's either 14 months or 27 months, and he got his hearing in 10 months, so there's no prejudice from his failure to raise this particular argument.
Absolutely. That is also on the menu of options. I would just say that because the practice of the states is so uniform, there would be nothing remarkable about this court predicting what the DC Court of Appeals would say and predicting specifically that it would side with the majority of states. But if this court feels that it is easier to simply say there is no prejudice because before this claim would have been fully developed, he had process in any event, that is certainly a path you could take. You could also take the path of saying that this claim is barred by Heck versus Humphrey. Judge Bates so found, and there was absolutely nothing in Mr. Hurd's opening brief to contest.
So we would have to resolve whether Heck versus Humphrey applies to people who are no longer currently registered.
No, Your Honor, I don't think you actually would have to resolve the split to rule for us on Heck, and that's because Mr. Hurd has at no point invoked an exception to the Heck bar. He simply said that Heck doesn't apply to him. That we believe is incorrect based on Edwards versus Balasag, which says if you're making a procedural due process challenge to the duration of your confinement. In that case, it was a challenge to procedural due process that ended up depriving someone of good time credits. That is barred by HEC unless and until the sentences or the term of incarceration is somehow otherwise invalidated. If
Wait,
Mr. Hurd.
So you propose that we would write an opinion that said HEC applies and we don't have to resolve the issue about whether it applies to people who are not incarcerated because he hasn't raised it.
That's exactly right. He didn't raise it below. He didn't raise it in his reply brief, which is the only brief in which he addressed HEC on appeal. So I think it's squarely forfeited. And if the court wanted to rule on HEC, I think it would be a simple path to take. And I don't think that the court would have to weigh in on the split. As to Mr. Hurd's time at liberty theory, again, there are 3 different options on the menu for resolving that claim against him. There's the HEC bar, which applies for all the same reasons. There's the fact that if he had had process earlier, the result would have been the same. He would have been denied credit for time at liberty. And we know that because he did in fact have a post-deprivation habeas hearing where that was the result. Beyond that, Judge Huvel and Judge Bates also looked at this time at liberty claim on the merits. Both found that it was lacking in support given the DC Court of Appeals rejection of a broad doctrine of credit for time at liberty.
We're out of time. Is there any further questions?
Thank you. We would ask that the court affirm.
I'd like to just address really one major point, which is merit, which is a substantive due process claim, at least was treated as such by Judge Bates in his opinion. And it was actually adopted by the DCCA in Wells as well. And so that was in 2002. And there's nothing inconsistent about Merritt and Lewis at all. In fact, they are married. They can be married. This court has found that they can be married together. How do you reconcile the shocks the conscience standard with more than mere negligence? Well, shocks the conscience standard was actually used in Merritt as well. And it, like I said, it was been around since 1952. It has to be more than just mere negligence. For example, some of the things that were talked about during shocks the conscience is always more than mere negligence. So doesn't that mean that more than mere negligence is not the standard? More than mere negligence is the standard. It has to be both. It has to be something more than just like a negligent clerical error. It has to be. So the question is, why is that part of the standard if the standard is also shocks the conscience? Because more than mere negligence is completely subsumed by shocks the conscience. So it can't be the Merritt standard because Merritt has this more than mere negligence thing, which is irreconcilable with shocks the conscience. If they said, I really don't like this person, I'm going to keep him in jail for the next 30 years. That would be above mere negligence. It would be intentional. So there's a spectrum. And I think, and I would just say. The issue, Mr. Gansler, is anything that's more than mere negligence is going to shock the conscience. So there's no room for a standard that requires more than mere negligence. It's Your Honor, it's actually a question for the jury. And given all the facts of the case. And what the standard is a question for the jury? No, how to apply that subjective standard of what is shock. That's not my question. My question is, how do you reconcile those two legal standards? Why can they be in the same legal framework? Because they're not reconcilable. Because in order for the jury to discern what is shocking the conscience, they use the factors that are in Merritt. And the district actually acknowledges that in their own brief where they say that there's a spectrum. After all, government misconduct sits on a spectrum in Lewis. At one end is negligence, Your Honor's point, which is categorically beneath the threshold, that's quoted, of conscious shocking behavior. And at the other end is unjustifiable intentional conduct, which, quote, is the sort of official action most likely to rise to the conscious level shocking. But in the middle range, there are closer calls where recklessness or gross negligence may cross the line. And that's where we are here. None of those, and if they don't shock the conscience, then they don't suffice under Lewis. Correct, and they were found not guilty. So that's not part of the legal framework. I guess I'm just having a hard time understanding, Your Honor. If you walked in front of a jury and argued this. I understand your argument. Yeah. Thank you.
Cases.
This common report has been adjourned.